Not in a quorum call.
Oh. Madam President, I ask unanimous consent that Olivia Rockwell, Brian Larkin, Elizabeth Isby, Benjamin Willis, and Elizabeth Durvan, legislative fellows in my office, be given floor privileges for the remainder of this Congress.
Without objection.
Madam President, the Senate will shortly consider the nomination of Courtney Elwood to be the CIA's General Counsel. And I wanted to take a few minutes this morning to discuss the nomination and put it in the context of the extraordinary national security challenges our country faces. And it is hard to imagine a more despicable act than the terrorist attack in Manchester Monday night, killing innocents, teenagers and children who are out just to enjoy a concert. The suffering that Americans and all in the Senate have been reading about, watching on television, is just heartbreaking by any standards. I think it's fair to say that as Americans, we stand in strong solidarity with our British friends, our allies, as they confront this horror. And our country will, as we have for so many years, will stand shoulder to shoulder with them as there is an effort to collect more information about this attack, what actually happened, and work to prevent future attacks. Now, not everything is known about the attack, but one thing Americans do know is that it can happen here. And that's why, as I begin this discussion, this important nomination, and the challenges in front of our country, I'd like to start, as I invariably do when we talk about intelligence matters, I'd like to start by recognizing the extraordinary men and women who work in the intelligence community, work tirelessly across the government to keep our people safe from terrorist attacks. So much of what they do is in secret, and that's appropriate. It's so important to keep secret what's called the sources and methods that our intelligence committee staffers are using. And it's important to the American people, it's important to our country to make sure that the people protecting them every day can do their jobs. Now, the reason I took this time this morning to talk about this nomination is to talk about the broader context of what we owe the American people. And I feel very strongly that we owe the American people security and liberty. Security and liberty, and that the two are not mutually exclusive, and that it's possible to protect the people of our country with smart policies that protect both their security and their liberty. Smart policies ensure that security and liberty is not mutually exclusive. And for example, I would cite as a smart policy, something I was proud to have been involved in, is Section 102 of the USA Freedom Act, which sought to make sure that we weren't just indiscriminately collecting millions and millions of phone records on law-abiding people, includes a provision, Section 102, that says that when our government believes there's an emergency where the safety and the security and well-being of the American people is at stake, our government can move immediately to deal with the problem and then come back later and settle up with respect to getting a warrant. And that was something that I thought really solidified what was a smart policy. Our founding fathers had a Fourth Amendment for a reason, to protect the liberties of our people. And so what we said is we're going to be sensitive to those liberties, but at the same time, we're going to be sensitive to the security and well-being of the American people at a dangerous time. And we're going to say if the government believes there's an emergency, the government can go get that information immediately and come back later and settle up with the warrant process. Now, these kinds of issues, ensuring that we have security and liberty, are especially important today. We obviously face terrorism. We're challenged by Russia, North Korea. The list could go on and on, Madam President. But the fact is, there are a host of these challenges, and it seems to me, if you look at the history of how you deal with a climate like this, too often there is almost a kind of easy, practically knee-jerk approach that is billed as dealing with a great security challenge and very often gives our people less security and less liberty. So at a time when people want both, they end up getting less. And that's what happens so often in crises. And far too often, it happens in large part because senior lawyers operating in secret give the intelligence community the green light to conduct operations that are not in the country's interest. So what I'm going to do this morning is walk through how misguided and dangerous decisions can be made today, and how much depends on how the lawyers interpret current law. In past debates, people have said, that happened years ago. Many years ago, and various steps were taken to correct it. Well, today I'm going to talk about how misguided and dangerous decisions can be made today. And at the center of this question is the nominee to be the CIA's General Counsel, and what I consider to be very troubling statements that have been made on a number of the key issues that involve decisions that will be made now. And in outlining those, I want to explain why it is my intention to vote against the confirmation of Courtney Elwood to be the CIA's General Counsel. The key principle to begin with, is there is a clear distinction between keeping secret the sources and methods used by the intelligence community, which is essential, and with the creation of secret law, which is not. We here in the Senate have a responsibility to make sure the public is not kept in the dark about the laws and rules that govern what the intelligence community can and cannot do. I believe the American people understand that their government cannot always disclose who it is spying on, but they are fed up with having to read in the papers about the government secretly making up the rules. They were fed up when they learned about the illegal, warrantless wiretapping program. They were fed up when they learned about the bulk collection of the phone records of millions of law-abiding Americans. And what our people want to know is that the rules are going to be, 1, clear to everybody, and 2, that their government is operating within those rules. So that's why the nominations for the intelligence community are so important. The American people need to know how these men and women understand the laws that authorize what they can and cannot do in secret. So shortly, the Senate will consider the nominee to be the CIA's General Counsel. I believe there are few more important positions in government than this one when it comes to interpreting key laws. The advice the General Counsel provides the Central Intelligence Agency will be shielded from the American people and possibly from Congress as well. There is almost never accountability before the public, the press, watchdog groups, or other public institutions that help preserve our democracy. There are almost never debates on the floor of the Senate about the legality of the CIA's operations. It's all in secret. Now, the advice of this General Counsel will carry especially important heft, given what the CIA Director Mike Pompeo said during his confirmation. Again and again during those confirmation hearings, when asked what boundaries Director Pompeo would draw around the government's surveillance authorities, the director responded he was bound by the law. In effect, the director said to the Senate and this body he would defer to the lawyers. So if Congress and the American people were to have any clue as to what the central agency might do under Director Pompeo, we were going to have to ask the nominee to be General Counsel. That was why it was critical that she answer questions about her views of the law and that she answer them now before a confirmation vote. So, Madam President, I asked those questions. And what I heard in return was either a troubling response or some combination of "I don't know" and "I'll figure out after I'm confirmed." Now, without answers, we're left largely to judge Ms. Elwood by her record. So I'm going to start by looking back at her previous service and what she says about it now. With respect to the National Security Agency's illegal warrantless wiretapping, that became public at the end of 2005 when Ms. Elwood was at the Department of Justice. She reviewed public statements about the program and held discussions about those public statements with individuals inside and outside the administration. That included discussions with the Department of Justice's Office of Legal Counsel and the department's legal analysis justifying the warrantless wiretapping program. She was especially involved when the Attorney General made public statements about the program. So the committee asked her about some of that Justice Department public analysis. In particular, the Department of Justice's January 2006 white paper that sought to justify the warrantless wiretapping program. Ms. Elwood responded that she thought at the time that the Department of Justice's analysis was thorough and carefully reasoned and that certain points were compelling. Madam President, this was an illegal program. It violated the Foreign Intelligence Surveillance Act. No interpretation of the law that defended that warrantless wiretapping program is carefully reasoned or compelling. It was an illegal program. Ms. Elwood also said that some of the analysis, quote, presented a difficult question and that, quote, reasonable minds could reach different conclusions, unquote. Of course, the point is not what reasonable minds might conclude. The point for us in the Senate is what her mind would conclude. Remember, this was the Department of Justice's conclusion that the law governing wiretapping of Americans inside the United States could be disregarded because the president says so, or because the Department of Justice secretly reinterprets the law in a way that no American could recognize. And remember, too, we are talking about a program that may have begun shortly after 9/11, but was still going on secretly and without congressional oversight more than 4 years later when it was revealed in the press. That was the context in which the Department of Justice, at the end of 2005 and the beginning of 2006, when Ms. Elwood was at the department, determined that the warrantless wiretapping program was perfectly legal and constitutional. This is to say, in my view, at the least, dangerous. And it could happen again. Now, I wanted to give Ms. Elwood every opportunity to reconsider and distance herself from these assertions I described. So I asked very specific questions. First, did the Fourth Amendment warrant requirement apply? No, she responded. She endorsed the view that the warrantless wiretapping of Americans on American soil did not require warrants under the Fourth Amendment. That was not very encouraging. But what about the other arguments made to try to justify this illegal program? The first was the notion that the 2001 authorization for use of military force somehow gave the government the green light to conduct warrantless wiretapping of Americans inside the United States. This argument was ludicrous. The authorization for use of military force said nothing about surveillance. The applicable law governing national security wiretapping was the Foreign Intelligence Surveillance Act, period. If the Bush administration had wanted a law to conduct warrantless wiretapping after 9/11, it could have asked the Congress to pass it as part of the Patriot Act. It didn't. So when they got caught and had to explain to the public what they'd been doing all these years, they said that the authorization for use of military force, which the Congress understood and authorized a war in Afghanistan, somehow magically allowed for wiretapping in the United States. The second argument was that the president had something called inherent power to disregard the law. I asked Ms. Elwood if she agreed with either of these arguments. She wouldn't answer the question of whether the authorization of use of military force authorized warrantless wiretapping. And she wouldn't answer the question of whether the president's so-called inherent power authorized the warrantless wiretapping. That was not very encouraging either. Now, I did get one answer. Ms. Elwood said that the argument that the Bush administration's secret interpretation of the authorization for use of military force combined with the president's so-called inherent powers allowed for the warrantless wiretapping, and I quote here, in her view, that seemed reasonable. That definitely was not encouraging. So then it occurred to me that having asked her about the past and some of these concerns that I've just raised, I thought maybe that's all part of yesteryear. Maybe that's all in the past. Let bygones be bygones. So I looked for assurances that Ms. Elwood's defense of warrantless wiretapping wasn't relevant now. After all, Ms. Elwood's response to questions about the program referred to the law at the time. Maybe current law makes clear to everyone, including the nominee, that there will never again be warrantless wiretapping of Americans in the United States. So what does the law actually say now? Back in 2008, when Congress took a big part of the warrantless wiretapping program and turned it into the law now known as Section 702 of the Foreign Intelligence Surveillance Act, the Congress wanted to make it absolutely clear that our country had really turned the page and that Americans wouldn't have to worry about any more violations of the law. So the Congress included in the law a statement that said, "We really mean it. This law is, quote, the exclusive means by which electronic surveillance could be conducted." So I asked Ms. Elwood about whether the president's supposed powers under the Constitution could trump the statutory framework, the current statutory framework in the Foreign Intelligence Surveillance Act. Specifically, I asked her whether that provision in law, the one passed in 2008 that explicitly states that the Foreign Intelligence Surveillance Act is the exclusive means for conducting wiretapping, would keep the president from asserting some other constitutional authority in this area. She said she hadn't studied the question. Now, this was the most troubling answer of all, because this is about how the law stands today. This is not talking about yesteryear. This is about how the law stands today. And this was the nominee to be General Counsel of the Central Intelligence Agency, not ruling out another assertion of so-called inherent presidential power to override the law. My fear is if the public can't get reassuring answers now to these fundamental questions of law, Americans could end up learning about the nominee's views when it is too late, when our people open up the newspapers someday and learn about an intelligence program based on a dangerous and secret interpretation of the law. It happened repeatedly in the past, and my message today is the Senate cannot let it happen again. Now, one of the reasons that Ms. Elwood's views on whether the government was obligated to respect the Foreign Intelligence Surveillance Act is so important is that, for the most part, the Central Intelligence Agency operates under authorities that are actually more vague than the Foreign Intelligence Surveillance Act. In fact, those authorities aren't even established in a statute that people in Iowa and Oregon could just go and read. The CIA's authorities to collect and use information on Americans and even to secretly participate in organizations in the United States are conducted under an executive order 12333. Now, in January, in the last 2 weeks of the Obama administration, the intelligence community released 2 documents that offer a little bit of insight into how intelligence is collected and used under this executive order. It was good that the Obama administration released the documents. More transparency is why I can come to the floor and be part of this conversation. But these and other publicly available documents demonstrate the extent to which the CIA deals with information on Americans all the time. Right now, the CIA is authorized to conduct signals intelligence as well as the human intelligence that's generally associated with the agency. And the intelligence the CIA obtains from various sources, which can be collected in bulk, inevitably includes information on law-abiding Americans. So what are the rules that apply to all this information on Americans say? What these rules say is, under this executive order, the CIA can mostly do what it wants. So if Ms. Elwood could find wiggle room in the airtight restrictions of the Foreign Intelligence Surveillance Act, I think the Senate ought to be asking, well, what might she do with the flexibility in the rules governing what the CIA can do under this executive order? In fact, even when this executive order includes limitations, there are usually exceptions. Guess who decides what the exceptions are? The CIA Director and the CIA General Counsel. In short, the rules look like an invitation to the CIA Director and the General Counsel to conduct secret programs and operations that rely on case-by-case decisions with no clear or consistent legal framework. That is why it's so important that these nominees give us some sense of where they stand before they are confirmed. Now, I started with Mike Pompeo, now the director of the Central Intelligence Agency. He wrote an article, an op-ed piece as it's called in the press, that called for the government to collect bulk records of law-abiding Americans' communications and combine all those records, and these are his words, publicly available financial and lifestyle information into a comprehensive, searchable database. That, in my view, is breathtaking. It makes what everybody was talking about with the old phone records collection effort look like small potatoes. So at his hearing, I asked then Congressman Pompeo whether this database would have any boundaries. In other words, he's setting up a brand new database, bigger than anything people have seen. It's going to collect people's lifestyle information and who knows what else. He said, of course there are boundaries. Any collection and retention must be conducted in accordance with the Constitution, statutes, and applicable presidential directives. So the real question is, what does that mean? It means that the person deciding what, if anything, Director Pompeo's CIA can't do is the lawyer. And that's where the nominee, Ms. Elwood, and to be General Counsel, comes in. So we might ask, how would these questions come up at the CIA? One question I asked Director Pompeo, hypothetical, was what happens when a foreign partner provides the CIA with information that is known to include the communications of law-abiding Americans. For example, what if the Russians collected information on Americans and instead of providing it to WikiLeaks, gave it to the CIA? It could be sensitive information about political leaders in our country and journalists and religious leaders and just regular law-abiding Americans. What would Director Pompeo do in that situation? When, if ever, would it be inappropriate for the CIA to receive, use, or distribute this information? His answer was, it's highly fact-specific. And he said he'd consult with the lawyers. So when she came for her nomination hearing, I said, this is our chance. Let's ask the lawyer, Ms. Elwood, the nominee to be General Counsel. She said, like Director Pompeo, that it would be based on all the facts and circumstances. She said she had no personal experience with such a decision and was unable to offer an opinion. This, in my view, is a prescription for trouble. We have a CIA director and a nominee to be General Counsel of the agency, and neither of these two individuals will tell the Congress and the American people what the CIA will do under these circumstances, which relate directly to the privacy of law-abiding and innocent Americans. In her responses to committee questions, Ms. Elwood referred to one of the documents released in January, the revised Attorney General guidelines, which she said imposed, quote, stringent and detailed restrictions on what the CIA can do with intelligence it collects that is known to include information about Americans. Now, we're not talking about an insignificant amount of information on Americans. We're talking about bulk collection. We're talking about information on Americans that the rules themselves describe as, quote, significant in volume, proportion, or sensitivity. The mere fact that the CIA collects and keeps this kind of information obviously raises a lot of concerns about infringements of Americans' privacy. So I wanted to know what these stringent restrictions Ms. Elwood was talking about in this program that she said would again just sort of magically protect the rights of Americans. Now, one of the issues that our people are especially concerned about is whether the government, after it's collected lots of information on Americans, can conduct warrantless backdoor searches for information about specific Americans. Those who dismiss the concerns about these backdoor searches argue that if the intelligence had already been collected, it's just no big deal to search it, even if the search is intended to obtain information on innocent, law-abiding Americans. The problem is, the more collection is going on, the bigger the pool of Americans' information that is being searched. This has come up with regard to Section 702 of the Foreign Intelligence Surveillance Act, which we're going to debate in coming months. As my colleagues know, a bipartisan coalition, a bipartisan group, Madam President, of senators and House members have been trying for years to get the intelligence community to tell us how many innocent, law-abiding Americans are being swept up in the Section 702 collection. That number, if we can ever get it, is directly related to whether the intelligence community should be allowed to conduct warrantless searches for particular Americans, and it is directly related to the point I offered at the outset, which is we must have policies that promote security and liberty. And if we do it smartly, we can have both. But these questions that I've described also apply to information collected under the executive order. And in the case of the executive order, there isn't even a discussion, not a discussion, about how much information about Americans gets swept up. So what do the rules say about backdoor searches collected by the CIA under this executive order? It turns out the CIA can conduct searches through all this information on law-abiding Americans if the search is, and this is a quote, reasonably designed to retrieve information related to a duly authorized activity of the CIA. So, Ms. Elwood has told the Intelligence Committee that there are really stringent requirements on this. But as I just read, that's a quote, reasonably designed to retrieve information related to duly authorized activity of the CIA. That sure doesn't sound like it's got much teeth in it to me. It doesn't sound very stringent to me. So I asked Ms. Elwood at the hearing what other restrictions might apply. In her written response, she referred to training requirements, to record keeping, and to the rule that the information must be destroyed after 5 years. None of that changes the fact there is no meaningful standard for the searches. There is no check. There is no balance. Even the CIA's rule that the information can only be kept for 5 years has a huge loophole. It can be extended by the CIA director after consultation with, guess who again? Consultation with the General Counsel. So again, we have rules that are vague to begin with, whose implementation is up to the discretion of the CIA director and the General Counsel. And at this point, Madam President, the Senate has virtually nothing to go on in terms of how this nominee for this critical General Counsel position would exercise all this power. Now, another aspect of CIA activities that are authorized by the executive order is the secret participation by someone working on behalf of the CIA and organizations in our country. These activities would obviously be concerning to a lot of Americans. Most Americans probably believe that the CIA isn't even allowed to do this anymore, but it is. The question is whether there are going to be rules that prevent abuses. So I decided, since that is yet another modern-day, present-time topic, I said, I'm going to ask Ms. Elwood some questions on this. For example, for what purposes could the CIA secretly join a private organization in the United States? The rules say the CIA director can make case-by-case decisions with the concurrence of the General Counsel. So I thought it'd be appropriate to ask, what's the view of the General Counsel, the nominee to be General Counsel? Ms. Elwood's response was she had no experience with this matter and looked forward to learning about it. And that, of course, was typical of so many of her answers. Repeatedly, she declined to provide any clarity on how she would interpret the CIA's authorities under this sweeping executive order. But these are the calls she could make every single day if confirmed. At this point, the United States Senate has no clue how she would make them. It's my view that you just cannot vote to confirm a nominee, particularly one who will operate entirely in secret and just hope for the best. Mr. President, I have other concerns about the Elwood nomination, particularly some of her views with respect to torture. And I just want to close by way of saying that at this extraordinary time in American history, and I would ask, Mr. President, unanimous consent that my entire statement be put in the record.
Without objection.
I believe at this extraordinary time, a time when our country, and if you sit on the Intelligence Committee, as I have, Mr. President, for a number of years, you go into the Intelligence Committee room and it's all behind closed doors, and you walk out of there often very, very concerned about the well-being of our people, given some of the grave national security threats we hear about once or twice a week. But the point is, our choice is not between security and liberty. It's between smart policies and ones that are not so smart. For example, on this floor, when the leadership of the committee was interested in weakening strong encryption, which is what keeps our people safe. You have your whole life wrapped up in a smartphone. Smart encryption ensures that terrorists and hackers can't get at that information. It ensures that pedophiles can't get access to the location tracker and pick up where your child might be. We all know how much our parents care about the well-being of kids. And so people were saying, well, let's just build back doors into our products. And I said, I'm going to fight that. I will fight it with everything I have whenever it's proposed, because it's bad for security, bad for liberty, bad for our companies trying to continue to offer high-skill, high-wage jobs because our competitors won't do it. And so far, we've been able to hold it off. But as we seek in the days ahead to come up with smart policies that protect security and liberty, we've got to get answers from those in the government who are going to have these key positions. And given the fact that the CIA director, Mike Pompeo, made it clear in his hearing that he was going to rely on the person chosen by the Senate as his general counsel, I felt it was very important that we get some answers from the person that we will be voting on shortly. I regret to say to the Senate this morning, Mr. President, we are largely in the dark with respect to Ms. Elwood's views on the key questions I have outlined today. And for that reason, Mr. President, I yield the floor. And I would note the absence of a quorum.
Clerk will call the roll. Mr. Alexander.